Hey, you didn't even shake my hand. What are you going to do about that? Now you must fall.
When I get a client and they first call me, you're right, like you said, we don't have a traffic accident report yet. We really know nothing about the case but what the client's telling us. And you're right, they want to know what the case is worth right off the cuff. The true and honest answer is we're not going to know right off the cuff what your case is worth, and any lawyer who tells you that they do is lying.
I was broken and built back up to win. This ain't nothing new to me. Yeah, my middle name should be Victory.
Welcome to the Victory Personal Injury Podcast. I'm your host, Jason Kidder, here with my friend Aaron Sebastian.
That's me.
Here, we're going to talk to you today about some personal injury questions that people want to know and want to ask. Most common of which is, how much is my case worth? Mr. Sebastian, people wonder, if I have a $100,000 case, what am I getting back? And I know people ask you that all the time. What's my case worth? What's my case worth? People always want to know ahead of time. They want you to see in the future. You haven't even seen a traffic accident report yet.
Right.
But people want to know, and they want to know generally from your experience, what exactly you think as far as what the real answer to that question is. Not the woo-woo answer, the real answer.
Yeah. So when I get a client and they first call me, you're right, like you said, we don't have a traffic accident report yet. We really know nothing about the case but what the client's telling us. And you're right, they want to know what the case is worth right off the cuff. The true and honest answer is we're not going to know right off the cuff what your case is worth, and any lawyer who tells you that they do is lying to you, because you don't know the full nature and extent of your damages. A lot of these cases depend highly on the damages, whether that's economic or non-economic damages. And what we need to know is, what evidence of those damages do we have to be able to prove the case and tell you what your case is worth. So that takes time.
Yeah. Well, in addition to damages, what's the most important thing that we need before we get into any of that most people don't understand? Because I've had people, get, rear end another car and they have whiplash, but they're at fault. Most people don't understand the most important part of this, which is,
we need to know that you're not at fault for the accident, first and foremost. And then second of all, we need to know you're actually hurt. We're injury attorneys. Just because you got in a car accident, you see car accident lawyers all over billboards, all over commercials, XY, etc. But what we really need to know is, were you actually hurt? We are injury attorneys at the end of the day. So we need to know, if you were hurt, how are you hurt, and how can I prove that injury to an insurance company or defense attorney so that we can get you compensated for those injuries.
So at the end of the day, we need causation, liability,
Yeah.
and damages.
Yeah.
And insurance, most importantly.
Yeah.
Because most people don't realize, just because you're hurt, if there's not insurance, you may be trying to sue somebody or asking us to sue somebody that potentially doesn't have anything for us to sue for.
That's right. I always say, like, the biggest thing we're always looking for, especially on those intakes, is there insurance? Is there somebody? Because a lot of people don't understand that if there's not insurance, there's no money. So I could go to court all day, win you a verdict that says $1 million. It may not be worth the paper it's written on from that judge or the jury verdict, because most people don't have $1 million laying around to pay you or compensate you. So the way that we get people compensated is through insurance. If there's no insurance available, of course we do our due diligence. We look through asset checks. We make sure there's nothing available that we could go after, trust, whatever it is. However, a lot of things are protected. So it's important to get your attorney on board early to make sure that we are exploring every avenue.
Let's talk a little bit about what an actual case is worth, because where we practice in Arkansas and Colorado, bodily injury coverage that everybody has to have is 25, 50, 25, 25 per person, 50 per accident.
Correct.
Okay.
Yep.
So a lot of people, they don't really understand that. And they don't also understand there's multiple avenues of recovery.
Yeah.
Because there is multiple insurance out there that people may be able to tap.
That's
and
true.
I
Before we get too far into that, let me break that down too, because a lot of people don't even understand that. So when you purchase insurance, you're not even really looking at what you're buying. You're just like, oh, it's the lowest price for getting my car insured and I can get on the road. So when you say 25/50, what that means is it's 25 per person. So if you have an accident with only one person, the maximum you can get out of that policy is $25,000. If there's a multi-car or accident and there's two people that are injured, great. Now you each have 25. But if there's 4 people injured in that accident, there's only 25/50. Now, what we do in those cases is we usually give everyone a pro rata share. So you look at you kind of you total up everyone's damages, everyone gets a piece of the pie and they get their fair share of the equal pie. I mean, at least that's kind of generally how it tends to work out.
Yeah. Well, and we were talking the other day, and before we started this today, we were discussing a lot of people don't understand that, even if they were hit by somebody that didn't have insurance coverage, that they might still be able to recover. We had that lady, obviously we're not going to say her name, but she came in the other day and they were hit, her and her husband, remember, they were hit by somebody who didn't have any insurance. And, we ended up telling her about UIM. And why don't, before we go further, go ahead and explain what UIM is.
So UIM is underinsured or uninsured motorist protection. It's something, it's a benefit you pay for on your own insurance. You can deny it. You have to deny it in writing in both Arkansas and Colorado. From my understanding, Arkansas, that's correct. Yep. So if you have that written denial, they have to keep record of that, at least in Colorado, for 5 years. If they don't, they have to prove that you denied that coverage. If you didn't give us proof, then I'm going to be fighting that you get coverage equal to your liability coverage. Now, back to what is actually UIM and UIM. Is uninsured motorist protection. What that means, if someone hits you that was not insured, your insurance now steps in their shoes, compensates you as though they were the one at fault.
Yep.
However, it's a contractual obligation, not a tortious one. So what that means is they have a higher duty to you to make sure that you actually get compensated for those injuries, as opposed to a liability carrier from the defendant.
Yeah, and just so the people understand, it's under and uninsured. So if you have somebody hit you who has no insurance, your UIM coverage would cover it, but it's also underinsured insofar as if you have damages of $40,000 in hospital bills, lost wages, etc., and they only had $25,000 in coverage, most people don't, and this is why it's so important to have an attorney on these cases.
Yeah.
People just don't understand. Your UIM coverage, if you have $40,000 in damages, the defendant's insurance has already written us a check because it's so obvious and your bills are so big. But now most people don't get, we still have more we can recover from our own insurance.
Correct.
Through underinsured motorists.
Right. So and generally the rule is that you have to exhaust the funds of the tort carrier, being the defendant's insurance, before underinsured motorist protection kicks in. Now, I'll tell you, that's generally true. That doesn't always happen in practice. Sometimes you can get some UIM protection if the UIM carrier believes the case is worth more than the tort is, even if the tort's willing to settle, or if your client's willing to settle for less than the tort maximum policy is.
By tort, you mean the personal injury?
The personal injury, the defendant's insurance. So, for example, let's say that we recovered $95,000 from tort, the defendant's insurance. It was a $100,000 policy, but UIM is convinced that case was worth a little bit more. They don't want to get hit for bad faith. They might pony up a little bit more, like 10, 15 grand, just to make sure they're not in bad faith, because again, that's a contractual obligation, not a tortious one.
I do want to talk more about bad faith too. It's another reason it is important to have an attorney. But I want to talk about this the subject that we started on a little bit more first too. So the what is my case worth question. Well, people also want to know, how much am I going to be able to get? Because at the end of the day, it's me. I'm saying me as the person who was injured. It's me who's suffered. It's me who's lost work. It's me, who has all of these damages, pain I might have to live with.
Right, you're not driving your kids to school anymore. You're having to hire people. You have to get Ubers. It's a whole thing. You have to move car seats. It's a freaking nightmare, man. That's why these injuries that we're dealing with are life-changing, and we at Victory here understand that they're life-changing, and we're fighting for the fact that they're life-changing. It's not just another day to collect a check for us. We are really passionate about trying to get you the full compensation for everything you felt throughout the process.
Well, let's apply it to a real case, because we've had these. I like $100,000 because I like 100,000, and plus it's just better than easier math. It's easier to follow along. Okay. So in a case where there's a $100,000 policy limit, which means somebody had some better insurance, thank God, everybody should.
Yep.
But we have damages, let's say, exceeding $100,000. I'm in a car wreck. I'm hurt. I broke my neck. I go to the hospital. I've got $60,000 and hospital bills that I have health insurance, and the health insurance pays it. But I've also missed, 3 weeks of work, and I've, had all kinds of other expenses. I've got a wrecked vehicle, all this kind of stuff. And, it has exceeded, my total case is worth well over $100,000. We get on the phone, we do this quicker because There's no point in us dragging this out. We want to get you paid back as quick as
Right.
we can.
Right.
But it's $100,000. We get the $100,000 from the insurance company because that's all the liability we can get to, other than maybe
Well, at least we have the
potentially
$100,000 offer on the table. We may
100%.
not have signed a release yet, but
Absolutely.
Yeah.
But getting back to the question, say we go through the whole process, we get the $100,000 from the insurance, we sign the release, we have a $100,000 check. People want to know, where does that money go and how much are they actually going to put in their pocket?
Mhm.
So let's talk about how it actually gets split up. And you were mentioning subrogation interest as far as the health insurance company that has paid those $60,000
Right.
bills.
Right.
They want their money back. But let's talk about how we actually, whenever we get that money, the back end process that nobody really knows, understands, or sees, and how we are able to get the most for our clients. Even though I know we have to get paid, we have an attorney's fee, there's some bills need to be paid. But at the end of the day, the question that everybody really wants the answer to is,
how much
am I going to put in my pocket?
Well, in that situation you just talked about, the likely outcome is that everyone's going to kind of end up with a third. And the reason that is because there's not enough money to go around. The case is worth much more than the available policy limits. So really what we're going to have is the attorney's generally going to get a third. We're going to try and reduce all medical bills down to a third, between subrogation interest and liens potentially that are out there. And then also the client needs to get a third. And frankly, here at Victory, we will reduce our fees to make sure that we're fair with the client, make sure that we put them in the best spot they possibly can be in, because we really truly do care about the client here. We're here to fight for them, not for just our own pockets here. But we also, this is a business, we have to get paid for the work that we do. And what I always tell people is, you're hiring a lawyer to negotiate, especially on the personal injury side. And whether that's negotiate with the tort carrier or the UIM and trying to figure out how much money we're going to get, or if that's set in stone because of the damages are too high, then now we're negotiating really with all of the providers to try and reduce those amounts as the best we possibly can, so that you walk away from this hopefully at maximum medical improvement and some money in your pocket, where if you were to just handle this alone, there's a good chance the insurance company maybe just pays those medical bills and you walk away with nothing.
Yeah. And I think we had a great example about this, where you might have, say you had $200,000 in medical bills and there's only $100,000 available for us to get. We get that quick. People are like, why do I need an attorney whenever I've already got medical bills that are, so high anyway? And you said something really good the other day at breakfast, and I really want you to say it again. I'm hoping I can just get you to do it without having to prompt you too much here. But people are like, when damages are so high, the insurance company, they're offering me the $100,000 right now. Why do I need you? And that back end part of the negotiation that goes on with subrogation and handling those bills.
Yep.
I don't think people quite understand that, and why it's so important to still have an attorney go in there, because what is an insurance company going to do if you don't have an attorney? And you've got $100,000 in bills. What are they going to do?
Likely, they're just going to start paying those bills. They're going to just pay them right off of your settlement, and you're not going to have a lot of say-so on how they get paid if anything got reduced. And before you know it, that could be completely gone before you even get a check. Now, they're not supposed to do that. That money is your right to figure out how it goes down. That's why us as lawyers are there to protect that right. They're not supposed to do that. But if you don't have a lawyer, man, some of these insurance companies definitely take advantage of that. And again, like I said before, we're really here to negotiate for you. If the reason you still hire a lawyer in those situations is, they might pony up the $100,000, but you also might get sued from a healthcare provider if they catch wind that you got that $100,000 and you never paid a bill. We're here to make sure that all the bills get handled, that you walk away with peace of mind that you're not going to be sent to collections. You don't have some sort of creditor coming after you. We send them paid in full letters, so it's more of like hey, you are entitled to this much. Here's a check with a check number for this much. You have been paid in full on this action. There will be no money after this. If they cash that check, at least we have a contractual argument that they were paid in full, even if they try to come after us later.
Because our clients have to be made whole.
That's right.
And most people don't understand what that means either.
Yeah, the made whole doctrine. Yeah.
Let's go into that and how it applies to subrogation. And that subrogation, I just want to make sure it's super clear, because I know we're throwing big lawyer words around here.
Mhm.
So subrogation, you correct me if I'm wrong here.
Yeah.
So subrogation is the subrogation interest that you say you had health insurance, Blue Cross Blue Shield, because that's what everybody I know has, but whatever health insurance, you have, $100,000 in hospital bills. Insurance actually pays, because they have the insurance
That's
discount,
contractual,
whatever. So they pay $48,000.
Mhm.
Okay, and that is their subrogation interest, what they actually took out of their pocket to pay your bills.
Mhm.
So that subrogation interest is what we actually try to negotiate and get rid of. That way we can have our clients made whole.
That's
and
right.
that's the argument we have to go fight. And this is, I think, the biggest behind the scenes fight that nobody really gets.
Yeah, I agree.
Because everybody thinks we're just pounding on the courtroom table.
Right.
But in reality, we're behind the scenes fighting with healthcare providers, fighting with insurance companies to make sure that our clients are made whole.
Mhm.
So go into that just a little bit more, how the subrogation, the actual bill the insurance company has, or what money they've paid, how we get them to not get that, and we put the money in our client's pile where it matters.
Yeah. So, and part of that's going to depend on whether the health insurance was what they call ERISA. ERISA is not subject to the made whole doctrine, because made whole doctrine is generally a state type law. Colorado has it. I believe Arkansas also has it.
When you say ERISA, I always think of the Shining, when the guy smashes through the bathroom door with the axe. He's like, "Here's Johnny." It's like, "Here's ERISA." It's a nightmare.
It kind of is.
But tell them what ERISA is first.
So ERISA is not subject to the made whole doctrine, because made whole doctrine is usually state law, and ERISA is federal, so it doesn't play by the rules of the state law. Therefore, what that means is they don't have an obligation to reduce their subrogation interest for the right of your client to be made whole or compensated fully. Now, granted, there's ways us lawyers still argue to kind of still get something in our client's pocket if in fact that is the case. But in a general case where you don't have ERISA, let's just go the easier route. You have Medicaid, or you have a regular
health insurance.
Then at that point, what we're trying to do is argue that with that insurance provider, whether it be Blue Cross Blue Shield, whoever it is, down the amount that they're entitled to. If, for example, our client wasn't made whole, and if depending on how much they weren't made whole, we can make an argument that they're entitled to zero, or they might be entitled to half. It really, maybe even a third. It depends on how much our client wasn't made whole. I mean, if you have $1 million hospital bill and only $100,000, it's pretty cut and dry that this guy was not made whole, and you should just waive your entire subrogation right. But if you have somebody who, maybe their entire case value is 120 grand, and they have an interest of 48 of it, maybe now we're only cutting off a third of that, and they're still getting paid something because they were pretty close to made whole on that situation.
Sure. Well, and it's funny you mentioned. I think we came up with the example of the Mexican standoff, right? Like, the reason our power in getting these insurance companies to come off these bills is because when our clients aren't made whole, we tell them essentially, like, hey, if you don't come off of your, say it's $1 million in bills the hospital actually paid, if you don't waive that,
or come down a little, so make it so our client gets something.
Well, if our client's not going to get something, he's not going to sign this release,
and the check's not coming, and nobody's getting paid. Yeah. And so, I mean, and we say, 50% of something's better than 100% of nothing. I mean, at the end of the day, that's the argument to the insurance company. The subrogation right is, hey man, like I understand that legally you may be entitled to this, but if you don't play a little bit of ball here, my client's not going to sign this release. I'm not getting paid. You're not getting paid. My client's not getting paid because, frankly, he's in a worse situation by virtue of signing this. Like, he owes you some sort of money. Maybe it depends. I mean, subrogation interest isn't necessarily what your out-of-pocket expenses for the client. The client might owe less money. So if he doesn't sign it, that subrogation right just kind of chilling out there, and nobody gets paid. So you might as well take, again, 50% of something over 100% of nothing, because my client won't sign it, and then we'll just walk away. Sad. I've had subrogation interest, their adjuster, whoever it is, say, hey, well, I'm going to get my counsel involved. Good. Maybe they'll understand the legal argument that you're not making here, because they don't have it. They don't understand it because they didn't go to law school, so they don't. And I'm sure in their training they're taught a little bit about this stuff, but not to the extent in which they can make legal arguments. I've had adjusters for subrogation and just send me essentially like legal letters that are arguing statutes against what I'm saying, and I'm like, yeah, but you don't even know how to read that statute. That statute actually says the opposite of what you're telling me it says, and I win. 100% I win. And if you want to get your attorney involved, please, I pray that you do, so that way I can have someone that understands the legal nuance that we're going through right now.
It would be nice sometimes to have some people with some legal.
Sometimes we got to sue just to get a lawyer on the other side, just so that I can figure it out if they're going to be reasonable per the law, because the adjuster just straight doesn't understand it. And then you also have to look at the whole, leverage. Some adjusters just get so caught up in like this is what it is. This is how much it's worth, and it's like, yeah, maybe. But here's the thing: if I sue you, maybe now your lawyer has to look at the legal nuance that you're not understanding. On top of that, they have to look at their exposure here. What could they be on the hook for if they do end up having a court? How much is litigation going to cost them? How much is their fees going to cost them? It's much easier to talk to the defense counsel about, hey, you should pay me this much, because and they can go make the reasonable. You have to tell them their reasonable argument to go tell their client to say, we should settle for this because you're saving this much money by not going to going through with the whole case. Now, a lawyer will understand that, but adjusters rarely get it.
Well, and they're trained to play hardball,
right?
And and if you're a layman, and if you're a civilian and a citizen, and you're not versed in this stuff, they will run over you.
You don't have a threat of litigation. You're not going to sue them pro se. They know that. That's just not going to happen. So you don't have the cannon on the other side just waiting to fire. Where like when I send you a letter, we have that cannon and we're ready to fire if that's what's going to happen.
We're just itching.
We're itching to pull it.
We're gonna send it.
Yeah.
But anyway, getting back to kind of what we were just talking about, and the threat of litigation being there, and getting reasonable people on the phone, and that's one thing we are constantly able to do, is to escalate past these bottom tier adjusters that would just give, if you were a client calling, they would call and be mean to you, which is just mind-boggling. I don't get why anybody's an ass on the phone with no reason. But
and frankly, I'm not usually to adjusters either. Now, if they're just arguing about the law and they don't know, for sure. But generally, I'm trying to be your friend. I'm trying to pour this bottle of whiskey with you, have a nice little moment where we can talk reasonably about the case, what it's worth, and how much my client. I'm trying to be your friend. I'm not trying to fight you until it's time to fight. Like right now. Nobody, and then, excuse me for my language for this, but nobody gets anywhere by being an asshole, generally. Like, the nicer you are, the better you're going to get. Now, if we're going to court, you best believe now we have to get the weapons out and it's time to go. But if we are negotiating, man, I'm just trying to give you everything you need to make sure you get my client what he deserves. That's all it is.
Ooh.
That's right.
And that said, though, we match energy here at the Victory Farm.
We do.
We will dish it out as good as we receive it. We'll do it with a smile on our faces.
That's right. Yes, sir.
It's all about our people, man.
Mm-hmm.
Well, you want to pivot just a little bit and kind of go back to, we got off on a tangent here because that's how it goes when we sit down and talk like this.
Yeah.
But let's go into some different kind of case outcomes.
Okay.
As far as
like what different types are worth.
Really getting to the nitty gritty for our people, because we started. I mean, we, and that's why this question's so dang hard to answer, man.
It is.
What's my case worth?
Yeah.
And it comes down to how much can we get the insurance companies to come off? How much can we get health insurance to drop? How injured are you? How much treatment do you have? And we had that one gentleman that we thought his case is worth about between probably $450,000 and $700,000,
right?
And we were halfway waiting. We wanted him to get more treatment, and then he ended up back in the hospital, and now that case is worth well over $1 million. But that's just how dynamic the situation can be, and how much change there can be. Yeah, and that's why that question's so hard to answer. But let's. For the best of our abilities, let's try and give these people.
So I mean, we have it. What I'd call it is there's kind of three camps you get into, right? So you have soft tissue cases, and what that means is that you had some pain and strain. You went to the you went to the chiropractor, maybe had some physical therapy, some massage, and that was kind of the extent of your treatment, right? Those cases, as long as you treated consistently, and the reason that consistency is important is because nobody who's hurt just deals with it. I mean, it depends. Some people, I would say blue collar workers, people who are athletes, tend to deal with it more because they're just used to being in pain. But most of the insurance company, the argument I always hear is hurt people get treatment. So you want to make sure that you're going consistently so that we have a nice paper trail that we can present that says, hey, they were hurt and they were hurt for this long. You should be considering pain and suffering for the amount of treatment that we're dealing with here. So anyways, with the soft tissue treatment cases, you're looking at maybe 4 months of treatment. You're looking anywhere from 15 to 30 grand, somewhere in there, maybe 45, 60 if it was more aggravated type stuff. Now, if you're looking at like the next tier, hold on a second. The next tier would be like injections where you get like cortisone or some sort of steroid to like kind of reduce inflammation so that they can continue to work on you. That's a little more invasive. Maybe you have a herniated disc. That tier goes up a bit more. You have, I'd say like now we're looking at 60 to 300,000 really. And I know that range is huge, but it really depends on your treatment and what doctors find within all of that and how much was pre-existing, how much wasn't pre-existing. Which brings us to a whole other eggshell plaintiff rule that we can talk about later. But then you also have cases in where you have slip and fall cases. And again, to the nature and instinct of those damages, it depends on if you lost wages, all of those things. Generally those cases, when you call me for a slip and fall, you're hurt. You're not, because most people are embarrassed by a slip and fall. Like
I was.
So you don't even give me a call. You just deal with it. But if you're actually hurt, like you ended up in the hospital, we have people who have 4 or 5 pins in their ankle. They'll never walk the same. That case could be worth anywhere from $1 million or more. It's really hard to say. But I would say those general slip and falls, man, for some reason because you're not expecting it, you don't brace yourself or anything, you really end up getting hurt. In those cases, I've seen them settle pretty well between 100 to 600,000 pretty frequently. So they're usually into the 6 figures.
And the soft tissue stuff you were talking about was more so you're talking about like car wrecks where people are, sore, they have neck pain, lower back pain, whiplash, that sort of stuff. But, it's still important to go get checked out because,
Oh, it is. Yeah.
I had, you remember I told you about this. I got hit twice. I had one car wreck where a guy drove all the way under my car, brand new car, thank God. And then the other one, I got hit with a trailer. And dude, that one spanked me. It ripped off half the side of the car. And I think by the grace of God, I'm fine. But both times, I'm a big dude and I'm a tough dude, man. Pain's not really much to me. We've both been through a whole lot of it, college athletics, all that stuff.
Yep.
But dude, I was not sore that day. But 2 and 3 days later, I was sore in bed. And people just don't realize, you can have a car wreck and you think you're okay.
Yeah. And,
you have adrenaline, endorphins, all kinds of stuff. You're worried, you're embarrassed, you're on the side of the road talking to a state trooper while people you work with are driving by on the interstate, all kinds of craziness. But you get home either maybe it's the next day, maybe it's several days later, and you realize, oh my God, I actually was hurt. So let's talk about the importance of, even if you don't think you are, going to the doctor and getting it done. Get yourself checked out because it cannot hurt.
And as someone who grew up not super well off, I understand a lot of people are like, I will never take an ambulance ever. Like, it's just, that costs too much. It's a dumb ride. Fair enough. Call your brother, your sister, your in-law. I don't care who it is. Have them take you to the doctor. Make sure that you get checked out. Whether it's just a PCP, fine. But generally, I'd recommend you just take the ambulance, take the blow, and go to the hospital, go to the ER, at least get checked out. Let them do their imaging, make sure everything's working good. Now, what I also say is, like you said, for the first couple of days, you're like, I think I'm fine. Well, the moment you start feeling pain, go to the doctor, okay? Because the sooner you show that you were feeling pain, that's that objective proof that we need to show the adjuster and the defense attorney, hey, a day after the accident, like after the adrenaline has settled, or even 7 days after the accident, when the adrenaline fully settled, this pain start creeping into their back, their thoracic lumbar area, and they really need to get into the doctor. So I would say always go to the doctor immediately thereafter. And also what's really important, I tell this to all my clients on our initial calls or consults, I suppose, is, be very weary of what your body's telling you. Your brain has this thing that tends to focus on the most immediate issue. Our brains are quite powerful that way. And that if I have a knee issue, it's going to focus all the pain is really in my knee. But as soon as that knee starts to feel better, man, my shoulders are kind of tight. My hip is kind of creaking a little bit, and it's kind of like a used car. You fix one thing, and it just feels like you change the alternator. Now the battery's bad. Everything else is bad. Like the belts are bad. You have to kind of change everything. that's kind of what it feels like with the auto accident, is that you fix the one thing that's the most immediate pressing issue, and then it realizes like, oh, all these other things were kind of affected in this too. And so I always tell clients, like, really sit there and consciously, it sounds crazy, but consciously think like, okay, are my ankles okay? Are my knees okay? My hip, how does that feel when I walk? Like, how's my chest feel? How's my shoulders feel? When I inhale and exhale, is there any pain in my ribs? You kind of need to think through everything. Did I lose consciousness? Did I hit my head? Like, think about all of those things on the upfront, so that when you go to those initial appointments, you make note of it. Because what I see a lot in these arguments from the other side is, oh, Mr. Sebastian, like, how can you tell me your client had this hip problem when he was complaining about his knee for 3 months, never even brought up the hip problem? Clearly, he was jumping on the trampoline with his kid or something like that, and that's how he hurt his hip. It's not a result of this auto accident. So the earlier we can identify all the pain points and the issues, the better off we're going to be, for arguing with an adjuster, but certainly in front of a jury for litigation.
And that's that correlation and causation aspect you talked about.
Yeah.
And showing that your injuries are a result from the actual,
Right.
I'm trying to think of the best way to say, let's just say car wreck, or however you were injured.
The incident, sure.
The mechanism of injury.
Yeah.
That one.
Correct.
That's what I was looking
The
at.
mechanism of injury, and that's super important. And that's I would say that's the main thing the lawyers are fighting about in this world is, are you actually hurt? Because sometimes people just are here for this payday, and they don't. We try to not represent any of that. We represent people who are actually hurt. But the next thing is, were they hurt as a result of this incident? Was this the incident that caused it? And frankly, that's when you kind of get into the eggshell plaintiff rule, and like, were you already kind of dealing with some things, but this really exacerbated your injuries and made them way worse than they were before, and now you are not the same. Like before, you were going to work, you were at your desk all day. Now you can't only sit for 30 minutes at a time before you have to stand up, take a break. Your production's going down. Your boss is threatening to fire you. Like, your whole life changes pretty quick. So.
Yeah, people don't realize just how much something like this can affect you, and all aspects.
And I see it all the time with personal injury. Oh, they've got priors, so we really can't. I don't know. But like, the big thing with priors is, okay, yeah, but how much was it way worse? And what proof do we have before the accident of what was their treatment like? How was their day to day versus after the accident? Even if they're hurt in the same spot, how much worse is it now via objective imaging or your day to day? Like I said. Before you're sitting in your desk 8 hours a day. Now you can only sit for 30 minutes before, or you feel like you're going to pass out from pain if you sit for too long, or if you walk with your kids, like you used to go for a 1.5 mile walk. Now you're only going around the block because it hurts too much. Like, those things are all proof, objective proof that I can have that show clearly they were hurt, even if it was the same spot that they've been dealing with for years.
Yeah, and I know for me, I try and always relate things back to my personal experience, but I've had lower back pain. I squatted a lot, did a lot of dumb stuff in college wrestling and high school wrestling, and I had back pain. And whenever I had that wreck, I was like, oh, it's just a little worse. But I actually think it was a lot of it worse. And I didn't go to I broke the rule, man. I was stubborn. I didn't go to the doctor right away. But hindsight, I really wish I had. And this particular case wouldn't have mattered anyway, because they didn't have hardly any insurance at all, other than what it was going to take to pay for my car. But, hindsight, what I really wish I'd done, and this is what I advise people to do, especially those people that are like, no ambulance, no hospital.
Yeah.
Hey, I know this podcast and us talking here today is probably not going to change some stubborn people, because I've been stubborn.
I've been that guy. I usually am that guy.
But if you're not going to go to the hospital, you're not going to take the ambulance, and you do have the pain and the injuries, the best thing I would recommend you do is find, if you have a chiropractor you love, and he's your family chiropractor, been there for years, whatever, go see him if that's who you trust.
Yeah.
But otherwise, go Google, because I guarantee you, especially in this day and age, get on Google, find a local chiropractor who does some imaging. A lot of them have x-rays.
Yeah.
A lot of them they can even refer for MRIs without you even having to go to the dang hospital. They have clinics that actually help people with this stuff.
Yeah.
But go see your chiropractor. At a minimum,
Yep.
He's going to be able to feel your back, and he'll know right away if you have like some new major problem. Because
Right.
they can tell if your hips are out of line. They can tell if your spine, if you're having a bulging disc or something like that. They may not be able to diagnose it.
Not right away.
But they can at least tell you if you're having a problem, and you have the beginning of that paper trail. In hindsight, man, whenever I got hit, I wish I'd done that.
Yeah.
that was a long time before we started getting really good at this.
Yeah.
But it's all that knowledge, and I'm hoping we can impart a little bit of that today.
Yeah.
Where do we want to pivot to now? We want to go into more of how the actual process works, and
Yeah, let's do that, because I feel like a lot of people don't understand the process, especially if you've had a criminal case or family law case. It's so much different than your lawyer interaction, so much different than you have with like a personal injury attorney. And what I mean by that is, it's just, man, there's with criminal and family, it feels like there's kind of things happening, like sparking off all the time.
there is urgency.
There's urgency, and there is urgent moments in this, and certainly if we get into litigation, there are. But with right off the cuff, generally what we do is we go through your case, we figure out who the insurance providers are, we send out letters of representation, let them know that they need to be talking to us instead of to you, and then really we send out all of our spoliation letters, make sure we're preserving evidence, all XYZ lawyer stuff. Once that's done, though, the biggest thing is you need to go treat and take care of yourself, take care of your body. And unfortunately, those damages are just kind of going to start to accumulate as you do so, whether that's lost wages or the fact that you got all these medical bills, or there's plenty, or out of pocket expenses because you had to do a bunch of different things you don't normally do. There's lots of different reasons those damages accumulate, but we need to know the full nature and extent of your damages. So the problem is we don't want to file a lawsuit or really start negotiating a claim before we know that full extent of your damages, because we could end up short selling your claim. And so what you don't want to do is, okay, you've gotten some soft tissue, you've gotten one injection. I've had plenty of cases where they have injections, they're like, I feel great, you should just settle the case. And then that injection wears off and it's still hurting. And then a couple months down the road, now they're looking at surgery, and surgery is going to cost way more. So you don't want to settle that case at the injection point, because that surgery is going to be a huge extent of those damages that could really put your case in the next bracket of what money you're going to receive for compensation, because you clearly had real and true objective big damages that was caused by their insured and they need to pay for. So that's really a big portion of it.
Well, and even going back to what we were talking about with UIM, we've got.
Oh, but real quick though, but so your lawyer's interaction, they'll call you and check on you, see how your update you with, just really at that point, your lawyer's trying to get updates from you as to how are you doing, how are you feeling, how are we getting close to like getting back to a normalcy? Because I feel like with criminal and family, you're calling your clients a lot to be like, this is what's happening, this is what's going on. With us, we're a lot like, we need to wait on you before once we get into negotiations, we'll be ringing your phone off the hook to be like, okay, we have this offer. Do you like this offer? This is why I think you should, why you shouldn't take it. Then we have lots of updates for you. Or same if we go into litigation. But during the life of the case, you're going to be talking to your paralegal and your attorney here. Like, I'll call you for sure because I just want to hear your voice. But just call you, see how you're doing, make sure that you're doing okay, see how your treatment's progressing. But as far as like updates on the case, there really aren't a lot of like updates to give you.
And I try and tell people these cases, they're front end loaded and then they're back end loaded.
That's true.
There's a whole lot that happens up front. We're getting traffic accident reports. We're finding insurance.
Yep.
We're going to get camera footage.
Yep.
You were stomping at 7-Eleven.
That's right.
Pagan finding that guy who was in the crosswalk, all that craziness.
Yep.
But I mean, we're going out, put boots on the
I'll
street.
show up on people's doorsteps to get insurance too, like in my suit, ready to go, buddy. Like I am not above that. And I've literally knocked and ring doorbell cameras. They're like, who are you? I'm sorry, who are you? Why are you here? I'm Aaron Sebastian. I'm an attorney. I'm here to see if you have any insurance for this auto accident. If not, I'll sue you for this beautiful home that you're living in right now. And usually I get a call by the end of the day from their insurance carrier that says,
amazing.
It's happened a few times.
But anyway, case is front end loaded. So, I mean, the sheer amount of letters, authorizations, everything that goes out, spoliation letters, all that goes out. And then there's kind of a lull. And it's not that we're not doing anything. We're getting your bills as they come in, entering them in, preparing that demand, to ultimately go out for whatever your injuries are, your damages are, getting all the documentation together.
Yeah.
But there's kind of a lull where, I mean, we're going to be talking to you once, twice, maybe 3 or 4 times a month, just depending on how much you have going on and how many bills we have to get in. But there's not going to be a lot going on kind of in the middle. And then the back end, we're way involved. We're getting demands, put together. We're telling you, hey, we think your case is worth XYZ. I think we send a demand for this. And then, you give us authorization to settle it between here and here. Obviously, we're going to try and get you as much as we can.
We have the same vested interest in that. the more I get you, the more I get me. So the more compensation I win for you, the more money the firm gets, and we're rewarded for the hard work we did.
Yeah. And man, let's go into that just a little bit, because I think people, you know, they think that 33% is just daunting, and dude, it can be. I mean, it's a big chunk of change, but the real value added that I think a lot of people don't necessarily appreciate, and it's why, I mean, lawyers are ethical people. I mean, they are, and we have a bar association that's really big on making sure that we treat people fairly. And I think people don't understand, like, when we take one of these cases, we have all the risk,
100%.
right? And you know, we front all the costs.
That's right.
We front all the money. We front all our time. We don't
That's right.
bill you for time or anything
Nothing.
like that. If we don't win,
we
don't
nothing.
get paid.
That's right.
At all.
Even if we invested in experts, which could cost $12,000 right off the cuff, like that $12,000 could be fronted by the firm to make sure that we put your best case forward. And if for some reason it doesn't go our way and we are wrong, we lose. We're out 12 grand right there. The firm just eats it. Like, and that's 12 grand that you didn't have to incur trying to put forth the same best argument. You just, you know, and so that's continue. Yeah.
I know you're good, man. But I mean, when people come with us, and part of, I mean, we put so much work in on these cases, and there's hours and hours, and we have staff members and stuff like that who spent hours poring over these bills, putting them in, making sure we get every damn dollar back that we deserve.
That's right.
Okay? But
and medical records. I mean, and these providers are never organized with how they send them. They're all over the place to get through this sometimes.
Yeah, although the dang medical bills and records are written in some sort of mystical code
Chicken
language
scratch
that
nightmare.
makes sense to people with RNs and doctorates. But I don't know, man. I got a doctorate too, and that stuff still doesn't make sense for the most part. It's really stupid. We can make it easier.
Yeah.
Anyway, the 33% though, you know, and you know, you and I, we've taken reductions where you know, ultimately it's more about, you know, getting our client as much as we can. But as to why we're worth it, though, why we're worth the money, we front all the costs, we take all the risk.
That's true.
We're going to work for you as hard as we possibly can.
Absolutely.
And ultimately, if you don't get paid, if we don't get you paid, we don't get paid.
That's right.
And we like to win here at the Victory Firm.
That's all we do is win.
It's in the name.
It's in the name. It's right there. You don't have to front me a $15,000 retainer and hire the $12,000 expert to potentially win your case. You can walk into my office and say, "Hey, man, I'm hurt and I don't have a lot. How can you help me?" And I'm here for that. That's one of my favorite thing about personal injury is that my legal representation doesn't discriminate against economic class at all. I don't care what you come from. I don't care if you're homeless. I don't care if you made $1 million last year. Literally does not matter to me at all. I'm here to help you the same way regardless. And I want to make sure that you get the best representation and advocacy that you could possibly receive, regardless of your socioeconomic class. It literally does not matter to me. And that's what I love about PI. You don't have to give me any money on the upfront because I'm here to make you some money.
Yeah. And one thing that does make us different too, and I do want to touch on a little bit, you know, we're coming up with, I want to call it a theme for the firm, you know, and our goal and our mission is to be better, not bigger.
Right.
We want to be the best law firm for our clients possible.
Right. The other big portion of what we bring to the table is that we truly, not to say that other attorneys don't, but we have more of a personal touch where we are trying to get to know you. I want when you walk into my office, you know, they say, "Hey, Jim, how's it going? Like, how was your daughter's whatever?" You know, because that's the type of service that we're trying to provide. I'm not trying to just, you know, I actually want to know my clients. I want to help them. I want to see them succeed. And it's not just about, you know, what their damages are and how fast we can quick flip their case.
Yeah. I bet there's very few lawyers who have been invited to their clients' quinceañeras and fed carne asada like you and me, dude.
That's right.
Yeah.
That's right.
Dude, and that, I mean, it really is the difference. Well, I had a couple notes. Some people had some specific questions they wanted you to answer. People are asking about this multiplier method and that whole, it's as far as
medicals.
Yeah, but we both know that's not really accurate.
No.
Let's talk about first off, let's make sure people know what we're talking about. The multiplier method being how they judge non-economic damages, right? Pain and suffering, lost wages, missed work, that kind of stuff, right? What is this multiplier? I'm gonna let you explain it because you do it way better than I do, but explain to them what this multiplier is and why this whole 3 times thing is just not the case.
Yeah, so a lot of people have this misconception that you're going to get 3 times your medical bills no matter what it is, doesn't matter what insurance they have, any of that. So, but there are a lot of factors that weigh into what your non-economic damages are, and really that's your length of treatment, how consistent your treatment was. Are you able not to walk anymore? Do you have scarring that is visible in a bathing suit that now you're embarrassed about every time you go out? These are the things that we're considering. It's not as easy as just one size fits all 3 times medicals. What the facts are is going to determine how well the outcome of the case is. As far as the 3 times medicals, it's just not accurate.
And I think
there are some cases that you get 5 times medicals. There's some cases you could potentially get 10. There's also some cases in where you don't even get 1.5 times medicals. It's not a multiplier of medical bills. It's truly how much damage did you suffer, and what was your pain and suffering really like, and how much evidence of that pain and suffering does your lawyer have to work with. That's what really it comes down to.
Yeah, and I mean, hey, you can have a horrible facial scar, and your medical bills are only $2,000,
and it could be a $150,000, $200,000 case easily, maybe more, depending on how young you are and how that's going to affect your ability to earn in the future or be successful.
Yep. Or married, or
were you in beauty pageants before? Were you about to be a runway model and be on Vogue? Because that person facial scar means a lot more than my facial scar, for example.
Hey, nah, you're pretty. That's the face right there.
Yeah.
But hey, so we're kind of talking about that multiplier, and people think it's 3 times. But what it comes down to, though, too, and that's part of what I love about our team, is we're actually going to know the facts of your case. You're not just some thrown together number file or cog of.
I know every name of every client I've gotten, what the facts of their case are right now,
and you understand their injuries
100%.
And whenever you have that personal touch, that intimate relationship with your clients, and you actually put the time into the cases, I feel like that makes you so much better and so much more effective as an attorney, and being able to settle, because you cannot fake care, and you cannot fake passion.
You can't fight for something you don't give a shit about. That's just absolutely true.
And man, I have to kind of commend you for it, dude. I don't think there's anybody better in the business at that than you. But
appreciate that,
dude. Let's take a break.
Yeah, let's.
All right, back to you.
I was broken